When you start thinking about getting a divorce, or your spouse tells you that divorce is going to happen, a lot of thoughts, feelings, and questions arise. You are about to enter unknown territory. Often, people go to a lawyer and ask what is going to happen. They want the lawyer to look into a crystal ball and predict how their case will turn out. In my experience, the actual outcome depends on a variety of factors. Most importantly, the facts of the case, but equally as important is the process that the person and their spouse choose to resolve their dispute. And finally, the people who are involved in the decision-making process. There are a variety of ways that people can get divorced. But before we talk about that, we need to go back to the beginning. Let's start when the story starts. When boy meets girl. They can't get enough of each other. They're attracted to one another, and when they're together, everything is wonderful. Now, if this couple just dates and then goes their separate ways, it's the end of the story. But this couple likes each other so much, they decide that they're going to get married. And when they do, they automatically invoke the jurisdiction of the place where they live. So in other words, if you're in Illinois, Illinois law governs your married relationship. If you're in California, California law applies. If you're in New York, New York law applies. Call it equity. But the point is, the law on the books does not cover every situation. Now, this couple who are happily married, they are working, they're making some money, they decide to buy a house, they have a few kids, put some money in the bank for savings, they have a few credit cards, and then mom has a business. That little treble clef is my symbol for mom teaches piano. She's got a piano school. Now things go along, and one day one of these people decides that they want to get a divorce. And there are different ways to get divorced, so we're going to start with litigation because that is the default method. With litigation, it starts when one person decides to hire an attorney. They talk and eventually file papers. The J represents the judge who stands in the place of the state. Those papers are served on the wife who then goes and gets her own attorney. So when you're litigating and you're constantly in the eye of the court, the communication, as you can see, is a bit like the game of telephone tag. Wife is talking to her lawyer, husband's talking to his lawyer. The communications generally go through the system, and there's not a lot of encouraging the couple to talk to each other. What typically happens is the lawyers are talking to one another to try to come up with a solution that's going to keep everyone happy. Ultimately, when the divorce is over, just like the priest says, you are officially married, the judge will say, you are officially divorced. And he or she will do that with a piece of paper called the judgment for dissolution of marriage. If they have minor children, it will contain a joint parenting agreement. That agreement will contain statements of where the children will live. It will set forth each parent's time that they have with the children. It will describe how the parents will be making key decisions for their children. The other document that's part of the judgment for dissolution of marriage is called the marital settlement agreement. That is where the judge will pretty much handle the financial pieces. Who gets the assets? Who gets the debts? Will there be money paid from one spouse to the other for the support of the children? That typically happens if one parent has primary responsibility for the children and the kids live with them. And then finally, spousal support, meaning money paid from the high income spouse to the low or no income spouse to meet that person, the spouse's expenses. Some marital settlements agreements also go into things like life insurance and college expenses for the children. No matter what, when it's over, we don't have that connection between the couple. We have two people. They probably live in two households. The children don't belong to one or the other. They share the children, and then each person has their own assets, debts, and income. This becomes the new normal. Another way to get divorced is called mediation. Now, mediation, we have the same background, the same family, we might have attorneys, but in addition, there is another person called a mediator. Now, the mediator's job is to get the two people to talk to each other. Some cases, there are lawyers hired ahead of time. In other situations, the couple may hire the mediator first and then hire a lawyer after the fact. The mediator knows all of the same topics that need to be resolved, and that person helps the couple talk to each other, that's that green arrow, to make decisions about the children, about the house, the assets, the debts, and ultimately write up a document called a memorandum of understanding. That is then given to the parties who have a lawyer or two lawyers prepare the same documents that I mentioned earlier, the joint parenting agreement and the marital settlement agreement. The difference is with mediation, the mediators help them develop the terms. Now, in some cases, you may have a couple that mediate and then the lawyer sees it and doesn't like the terms. So that's one of the risks of mediation. But generally, if both parties are on board with mediation and the mediator helps them resolve everything, the lawyers should be entering the document that they're developing. Now, I'm going to talk about collaborative law. It's another way that a couple can choose to get divorced. Now, when we start out talking about a collaborative law case, we've got the same couple, same children, same assets, same income. We have the same state laws in the background. We have the same sense of equity and justice. Now, if you look, we also have two lawyers, so it looks like litigation. However, they're blue. These lawyers are trained in the collaborative law method, and they are hired by the people in a particular way. So let's talk about the features of a collaborative case that make it different than a traditional litigated case. First of all, the couple and their lawyers agree that they are going to settle the case. So the retainer agreement, the engagement agreement that the clients have with their respective attorneys, states that the lawyers are hired to settle the case and they are not going to file any contested motions with the judge. Now, the judge in the legal system is there in the background, and it helps the people make their decisions and discuss things, but the judge will not be called upon to make a decision in the case. The couple will be the final decision makers in how the outcome comes out. Second feature of collaborative law is that we have full voluntary disclosure. If you're in a litigated setting, the parties can file subpoenas, do interrogatories, have depositions, which is called formal discovery. In collaborative, everyone has the same duty to provide the same information. We just provide it voluntarily. So if either party wants to see another person's bank accounts, all the statements are produced. If one of the parties has a business, which tends to be the most complicated in terms of disclosure, the party who owns and operates the business agrees that everything that the other side wants is going to be on the table, fully there in everyone's plain sight. A successful collaborative case requires that the two parties at the table are bargaining in good faith. In other words, they really do want to resolve their case. They're not using the collaborative law process just to make the other party hurt. A feature of collaborative law is that we meet, and it says four-way meetings because the attorneys and the clients are all in the same room. In a traditional litigated situation, the husband's lawyer is prohibited from speaking directly to the wife unless her attorney is present. Likewise, wife's attorney cannot speak to the husband unless husband's attorney is present. So what I say is that it allows for the cross communication and more problem-solving approach. It allows for each attorney to get a better relationship with the other side. And because collaborative lawyers are generally trained as mediators, we see our job as trying to find an outcome that's going to satisfy both parties' most essential needs and take care of the children and have a long-term impact that if there is a family business, that the family business can remain viable and help the family move forward. So the more information that's on the table that everyone has access to and everyone can discuss openly with one another, the better the outcome can be. And when you have all the parties at the table at the same time, it actually moves things along more quickly. Which brings me to our next feature, the team approach. Now, here we have the basic collaborative law case where we have two parties and two attorneys. In addition, there are other professionals who are trained in the collaborative model. Starting with the CS stands for Child Specialist, and the N represents that this person is neutral. So in collaborative law, if there are children, we can use a child specialist to help the parents develop their parenting plan. In some cases, the child specialist will meet with the children. In all cases, the child specialist will meet with both parties and help the parents develop a parenting plan. Sometimes we have various iterations. So they'll come up with a parenting plan, they'll try it out. If it doesn't satisfy one or the other, then we tweak it a little bit. Let's try a different situation. Another neutral professional is the coach, a neutral coach that can help the whole entire team. Coaches are generally mental health professionals who specialize in divorce. Their job is to help the parties communicate better, to help the team understand the dynamics of the family, and overall keep the case moving forward so that everyone can stay in communication and committed to the collaborative process. Some cases involve coaches that are not neutral. So as you see, there's a C coach for the husband and C coach for the wife. The lawyers at the beginning of the case will most likely discuss which they think is better for the family in their particular situation. Is a neutral coach better, or should each party have their own coach? And finally, there's a specialist called the financial specialist. And as you see again, that person is neutral. They're generally certified financial planners, certified divorce financial analysts, and their job is twofold. First, they're going to help the team by gathering all the financial information, making sure it's accurate and correct, which helps everyone get a clear sense of, okay, this is our baseline information, and if there's any disagreement or lack of understanding, the financial neutral helps to get everyone on the same starting page. The next phase of work that a financial specialist will do involves helping the couple and the professionals explore what are the financial ramifications of various settlement scenarios. They all work together. So sometimes the coach is helping the financial specialist understand the dynamics. Sometimes the lawyers are helping the coaches understand the legal issues. But generally, if you have an interdisciplinary team, all the professionals are speaking with each other, they're meeting with the family, and they may be meeting with the children. In any case, the end result is the same. We want a judgment for dissolution that includes a joint parenting agreement and a marital settlement agreement that covers all of the key issues for this family. The difference, in my opinion, is that a collaborative settlement is very forward focused. So this couple, who's now no longer a couple, they're a man and a woman that must co-parent and live side by side, their settlement is durable. They have taken ownership of the result that they have to live with, and they are going to go forward and build their lives in a way that's going to be functional for their children. Now, I've described various ways to get divorced. I'd just like to point out that the divorce is not the end of your life. It's just one stop on the journey. You're going to make it through, you're going to take a little breather, and then you're going to set off on a new journey that starts after the divorce. And for you, I hope you realize that it's not one size fits all. You need to first get clear about what are your goals for yourself, for your children. How do you want to relate to your spouse in the future? And if you have a family business, what do you want for your business going forward? Secondly, decide which of the processes will help you achieve those goals. And then finally, get the people involved who are going to help you reach your goals. and may you choose a path that will bring new life to you and your loved ones. Thank you.